We're going to be talking about subcontractor labor, 1099 installation labor in the industry, arguably the _1 liability. Some people could say it's telemarketing off of bad lead generation. That's a very complex topic that we won't have time to get into, but the use of independent contractor labor is clearly one of the big problems that the industry has had for the past couple of years, and it's on track to be one of our larger problems in 2022. We're going to talk about contract structuring from 30,000 feet, and also lead paint, which everyone seems to think has gone away, and I assure you it is not. So I think we've got is the first screen up there, Tim? It looks like it is.
It is, yes.
Okay, so let me explain before we get to the screen. What we're talking about, the problem started primarily under the Obama administration. It's moved forward exponentially, took a little bit of a hiatus under Trump, but not too much of one. The utilization of independent contractor labor, which is prevalent in the industry, is a nuclear problem. Can it be done? Yes. Despite all the employment law firms out there and all the accounting firms telling you you can't run 1099 labor, you absolutely can, but it is difficult to do so. And the takeaway I want you to have is if you're not prepared to build a brick wall around your installer relationships, then you seriously need to convert those installers over to W-2 employees, as expensive as that is. Because if you're not going to do it right, if you're not going to protect yourself, and nobody else is, if you're not going to protect yourself, you're facing a potential nuclear disaster. What do I mean by that? If the installer is up on a ladder doing roofing or windows or whatever your installers are doing for you, and they break an ankle, it doesn't matter that this person is your a godfather to your son or your daughter. You've had them over for dinner multiple times. They're going to come after you. They're going to go to the wrong 1-800-SUE-YOU lawyer, and they're going to come after you. And when they come after you, they're going to be seeking the payroll taxes that were never paid at the state level, as if they should have been a W-2 employee, the payroll taxes at the federal level. They're going to be seeking workers' compensation. They're going to be seeking health insurance that they would have gotten if they'd been an employee, perhaps retirement benefits that you give to your employees, a SEP, IRA, 401k, whatever it may be, plus penalties and fines at the state and federal level. And so when you add all that up, including the legal fees, you can never forget the legal fees, you're easily looking at a claim of $100,000 or more for one installer over a year or two. And then they often will go back and try to get their buddies, and they'll try to rig it up into a class action. So it's kind of like a domino effect when you get hit with one of these reclassification attacks. They come in from the IRS, they come in from the Department of Labor, they come in from state wage and hour, and as I indicated, they come in from the installer themselves. So to build that brick wall is a complicated matter. It's not something that we can discuss in 15 or 25 minutes. It's state specific, it's product specific, but let's at least talk about the basic bricks in the wall, what we must have. So when you see on the slide, you first of all have to have a written agreement with your independent contractor installer. And you need to have a written agreement anyway, right? Because you want to have a mechanic lien waiver, maybe you want to have a retention fund holding back a little piece of every job. So when they walk off the job, you've got a little something that you can use to fix up what they've done wrong, et cetera, et cetera. You need to have that written agreement, but it has to explain that this is going to be an independent contract relationship. Without that, if you get audited, if you get attacked, you're pretty much dead in the water. The second brick is that you have to hire these individuals as what we call IBEs, or independent business entities. That means you've got to hire them as a company, corporation, limited liability company. You could even hire them as a sole proprietorship if you wish, but you can't hire and pay them under their own name. You're going to lose if you get attacked, and anybody sees that. They have to be filing their own employer identification number, meaning they have to have registered with the IRS. They must have a separate tax identification number from their social security number. And if they're running as a sole proprietorship, if it's Johnny Jones and he's Jones Installations, okay, he's supposed to have a separate tax identification number anyway. And he must, from our point of view, if you're going to be able to build and protect that brick wall, that relationship. Professional licensing, this is always the most difficult one. We know in about 38 states, our industry is regulated fairly heavily. And if a general contractor is in a state which requires licensing, then the independent contractor installer needs to have licensure. Now in California and Nevada, that's the law. If you're paying an installer on a 1099 basis, they have to be independently licensed. But in any state, they need to be independently licensed if you're going to protect that relationship. Why? It's just a question of logic. If you're arguing that Johnny Jones is truly operating his own business, then Johnny's got to be licensed to operate that business. And if he's not licensed to operate that business, carpet installation, window installation, roofing, whatever it may be, you're not going to win the argument when Johnny comes after you, or the IRS, or Department of Labor, or Wage and Hour, or whomever it may be. So you've got to make sure that Johnny's independent business entity is properly licensed. And then we've got pay per job. The pay per job is not difficult. What it basically means is that when you're cutting your check, whether you're paying these guys piece rate or on a commission structure or hourly, whatever it is, you need to designate on the payroll system on the check the jobs that they're getting paid for, each particular job. That's it. But you just can't pay them a lump sum as if you were paying an employee. Now, work for others. Okay. These days, most of our installers are gainfully employed with us, meaning they're working full-time with us, right? They're not probably working for anyone else. If they are, that's great. They don't actually have to be working for other people, but we need to be able to show that they could be working for other people. So how do we do that? They get a one-page website up. They get business cards. They go into the yellow pages. They advertise. So we can prove that, in fact, they are holding out their services to others, even if they're really only working for us. Okay. Then we have the IRS filing. We have to be paying these guys and issuing them a 1099 miscellaneous form. Right. Now, if they're a corporation, if they're a C corporation, you don't have to do that. That went back and forth under the Trump administration, but you don't have to do that. But for any other type of entity, which again, they must be, you need to file and issue them a 1099 miscellaneous form. And then finally, there's a question of their tax returns. And this is what we call the silver bullet. As Tim indicated, one of my nefarious backgrounds is Office of Chief Counsel of the IRS. So what happens when these guys sue us or Wage and Hour comes in and they say, you know what, you owe us $150,000 because Johnny should have been an employee over the past 6 months, 2 years, 3 years, whatever. Okay, Johnny wants a piece of your pie. If we're able to show that we've got a cover page from one of Johnny's independent business entities tax returns, right? So we hired Johnny as a business entity, okay? And we said, you've got to give us the first couple pages or the first page of your tax return. Now we're sitting there across from the 1-800-SUE-YOU lawyer. And Johnny and he are saying, Johnny really was an employee and he was entitled to all these benefits and you owe $150,000. And we can pull out the cover page from the tax return that Johnny gave us for his company, showing that he filed with the federal government, with the IRS, as Jones Installation, and that he took his expenses as deductions. Then we say, well, there's a little bit of a problem here because you're saying that Johnny should have been an employee, but we've got a document here, a submission signed by Johnny to the Internal Revenue Service saying, in fact, he was a business and he took against his taxes business deductions for his expenses. So you can't have it both ways. So either Johnny committed tax fraud and he should have been an employee, or Johnny was never an employee and he didn't commit tax fraud. So I'll pick up the phone and call the district director of the Internal Revenue Service and we'll walk through this right now. And you'd be surprised at how quickly we are able with that strategy to shut down these claims from the installers. But it helps immensely if you've got a copy of the tax return as part of your onboarding procedure. Again, these are just a handful of the bricks that are necessary to build that wall. There are usually 15 or 20 bricks in each state. And again, it's product specific. And some of the bricks are more important than others. I can't tell you how many bricks you can pull out of the wall and still have structural integrity. But I can tell you, if you build the wall properly, we at least at our firm have never lost an audit or an attack with proper protocols. So again, the takeaway here is if you're going to run 1099 based installers, understand the risks are substantial, build that wall correctly or don't, and move them to W-2. Otherwise, your exposure is tremendous. Okay, now, none of this brick wall is going to work for sales representatives. There's an entirely different structure we use there. It's called Section 3508 under the Internal Revenue Code that allows you to treat your installers as if your sales reps, as if they were independent contractors. Completely different conversation. I just want to make sure everybody's aware of this. We're talking about installers only here, not sales reps.